Not quite sure the right screen is being displayed for the YouTube side of the call.
Mr. Nelson, when do you anticipate Mr. what's it, Oendorf being called?
Mr. Orndorff will be called.
It'd be great if it was in proximity to this conversation right here.
I'm delighted to call him next. We had anticipated calling him after Mr. Collins, but we can put him on right after Mr. Gorman while the topic is fresh, if that's helpful for the commission.
No questions? Does that sound reasonable? Very good. Thank you. So we'll be back on the record then. Okay, proceed.
Let's talk about the resources you dispute in Northwestern's portfolio. You dispute the Beartooth battery because it was recently terminated, right?
Yes.
As of April 29th, 2022, Northwestern was moving forward with the Beartooth battery, right?
Can't confirm that. I'm not sure when they decided to terminate the agreement.
Do you have any reason to dispute that?
I don't know when they decided to terminate the agreement.
Right. The district court had not ruled the pre-approval statute was unconstitutional as of April 29th, 2022, right?
Not that I know of.
The pre-approval application for the Beartooth battery had not been dismissed as of April 29th, 22, right?
I'd have to confirm that. I don't recall when the pre-approval application was withdrawn in that general time frame.
Yeah, the commission can take administrative notice, like of order number 7824C in the pre-approval application for the Beartooth battery. It wasn't dismissed until October 18th, 2022.
Any objections to that?
No objection.
Ordered, yes.
And no announcements had been made regarding the termination of the Beartooth battery contract as of April 29th, 2022, right?
Not aware of any.
And you also want to exclude the PowerX PPA and Heartland agreement from Northwestern's capacity analysis, right?
In terms of putting them ahead of us in the queue, I think that's inappropriate.
You admit that the PowerX PPA was executed in April of 2021, right?
So
You can- Oh, sorry. There's a chart on page 30 if you want a reference of your rebuttal testimony.
yeah, that's based on the company's response to data requests. April 16th of 21.
And
April 16th of 21, sorry.
you admit that the Heartland contract was executed in December of 2021, right?
Yes,
Both of those contracts were executed prior to April 29th, 2022, right?
prior to that date, yes.
You want to exclude Trident, Broadview, Meadowlark, and Upland Dillon, Argenta Solar from Northwestern's capacity analysis for kelp, right?
In terms of excluding the determination of whether or not kelp's capacity is needed by Northwestern, they shouldn't be moved ahead in the queue to Northwestern.
They represent the 403 megawatts that you want out of Northwestern's analysis, right?
It's 403 megawatts of nameplate capacity that should not be put ahead of kelp.
Are you aware that all of the commission's rules are publicly available?
It's generally consistent with my understanding of regulatory commissions, yes.
Are you aware that the commission has a rule that sets criteria for a QF to establish LEO?
I'm aware of FERC's established rules for an LEO, yes.
Are you aware that Trident submitted an estimate of its energy production and interconnection application, a unilaterally signed PPA, evidence of site control, copy of its permits, and requested to be studied for interconnection before Northwestern included it in its resource portfolio?
No, that's Northwestern's position, yes.
And do you have any reason to dispute it?
Only the conclusion that they should be moved ahead of kelp in the capacity queue.
But no reason to dispute any of those facts.
I'm not disputing those facts.
Okay.
Or those representations.
Are you aware that Broadview and Trident submitted those same documents before Northwestern included them in its resource portfolio?
It's my understanding.
Are you aware that Upland Dillon Argenta Solar submitted those same documents before Northwestern put them in its portfolio?
It's my understanding.
On page 9 of your rebuttal testimony, you state that you disagree with Northwestern's position regarding when kelp established the LEO. Is that right?
Sorry, can you, page 9?
Page 9 of your rebuttal.
Direct me to what you're referring to.
If it helps, Mr. Gorman, I think he's referring to lines 15 through 17 on page 9.
I do dispute the placement in the capacity queue in making this determination. And I believe that that point estimate is largely related to arguments around the LEO.
Are you familiar with the petition Kelp filed in this matter?
Yes,
And I think you testified earlier that you helped put it together.
yes,
And I believe you have that petition up there with you. Is that right?
I believe I do. Yes, yes, I do.
Can you go page
Oh, I'm
13 of
sorry.
it? I'm sorry.
Page, I'm sorry, I didn't hear what page you just read.
13, please.
There.
Kelp's petition claimed an LEO of April 29th, 2022, right?
It does.
Kelp never amended that position to claim any other date, did it?
Well, I'm not sure how you're using this with respect to, the proposed new PPA or the LEO that existed under the existing PPA. So I guess there may be more layers to that argument than you're implying. But as far as I know, in terms of the way it's used in this paragraph, request was not made to change that LEO date.
Okay. And Northwestern never contested Kelp's LEO date, right?
I don't believe so.
Why did Kelp choose April 29th, 2022 for its LEO date?
That'd be the date this was filed. As opposed to the dates Kelp sought communications and negotiations with Northwestern to extend the contract, which began several years prior to that.
Did you choose April 29th, 2022 because that's the date Kelp sent Northwestern a unilaterally signed PPA?
That specific language there, I know that was the date. I believe that was the date we filed the application for PPA.
If you want to take a look through that petition there for me. I believe it was
Okay.
filed. Do you have, is there a filing date on it?
Um,
Okay. Can you go to paragraph 32 of that petition?
I'm there.
Can you read it for me?
Recently, Kelp executed and tendered an amended and restated PSA to Northwestern, which included price terms on April 29th, 2022.
So is that why you Kelp chose April 29th, 2022 for its LEO date?
I mean, that was the filing date of that package, yes. So
Okay, so you believe that the LEO date should be Kelp's LEO date was chosen because it was on the same date that it sent that unilaterally signed PPA.
I can't say that the LEO date was based on that single fact of when they offered a signed PPA agreement to Northwestern.
Are you saying Kelp's PPA dates, or are you saying Kelp's LEO date should be anything but April 29th, 2022?
Saying you're asking for the trigger which rendered the LEO date. Saying that was likely one factor, but I cannot say it was the only factor.
Right. But right now, is Kelp claiming any other LEO date other than April 29th, 2022?
They are not, and that's not what I'm trying to explain to you. I don't know if that date was chosen based on that single factor.
Right. But if are you contesting any of those other QFs LEO dates? And when I say other QFs, I'm referring to Trident, Broadview, Meadowlark, and Upland, Dillon, Argenta.
My opposition to Northwestern's filing is that they're moving them ahead of Kelp in the queue for establishing capacity resources needed to meet their retail load obligations.
Okay, I have no further questions.
Good, thank
Thank you.
Mr. Brown,
No questions. Thank you.
legal counsel.
Thank you, Mr. Chairman. Mr. Gorman, just a few points that I'd like to try to clarify. It's my understanding under Kelp's proposal that Kelp would be paid for 37 megawatts of capacity in months from October through May and 32 megawatts of capacity in all other months. Is that understanding correct?
Well, that's the minimum they will provide under the terms of the contract in each of those two time periods.
Okay. And so we would take the minimum provided in each one of those months and multiply that by the commission ordered capacity rate. Is that correct?
Well, they will get paid for capacity delivered. So to the extent it exceeds the minimum, they'll get paid for all capacity delivered.
Okay. Will Kelp be making any sort of a standing nomination of either 32 megawatts or 37 megawatts, depending on the month, in all peak hours? Or do I understand you correctly that it will vary?
Well, there will be scheduled today in advance of the amount of output from Kelp to Northwestern. So Northwestern will know what the schedule is for deliveries from Kelp. But it's Kelp's obligation to provide no less than the minimum capacity contributions on average each peak hour of each peak day in those time periods.
Okay. So then it's possible in an hour for Kelp to have scheduled less than, say, 32 megawatts in anticipation that later in the month it will schedule more than 32 megawatts and therefore meet its average. That's possible.
It's possible, but the economic operation of the unit, they're going to sell both capacity and energy to Northwestern, and they maximize their revenue by doing just that. So they're not going to reduce capacity payments at the beginning of the month, maximize them later in the month because they'll lose energy sales. And it's in their economic interest to make energy sales, particularly during on-peak hours. So it would be illogical, economically illogical for them to not maximize revenue collections from Northwestern, which would mean providing as much capacity as Northwestern needs on a day-ahead basis and earning revenue from the energy sales.
Okay. Is Kelp required to achieve any sort of performance or availability requirements to receive a full capacity payment other than that monthly average?
That is the incentive for Kelp to perform under the contract. If they don't meet the minimum average capacity contribution during peak hours, then there will be a revenue loss to Kelp in the form of reduced capacity revenue collections.
Okay. Do you still have your direct testimony
Yes.
available?
I do.
Could I refer you to page 4 of your testimony?
I'm there.
All right. On lines 13 through 20 of page 4 of your testimony, you describe how during off-peak hours, Kelp may deliver capacity when it is economic based on either real-time or day-ahead LNP energy prices. The paragraph continues from there, but do you see where I'm
Yes.
at there in the discussion?
I do. Yes.
All right. Will Kelp receive any sort of capacity payment for nominations of capacity in off-peak hours?
No, the capacity payments are produced by delivering capacity during on-peak hours.
Okay.
If there are operating limitations which require them to maintain a minimum operating levels of the unit during the off-peak hours, and what they're concerned about is being asked to deliver energy into an energy market, which makes it economically unattractive to deliver a lot of energy into that market. So they want to operate their facility economically. When they do that, it doesn't harm Kelp and it doesn't harm Northwest Energy, because to the extent energy prices are low in that off-peak time period, then those energy prices are already available to Northwest Energy. So Northwest Energy is indifferent and their customers are indifferent, but Kelp is able to operate their facility in an economic manner.
Okay. What criteria would be used to establish when Kelp will nominate and deliver capacity on a day-ahead basis in off-peak hours?
The process typically will be Kelp's ability to look at day-ahead energy prices and see whether or not they represent an opportunity for them to at least break even on energy generated in the off-peak period. To the extent they make money for selling energy, then they likely would want to do that. But the real concern is uneconomic operation. When off-peak energy prices may be so low, they effectively want to minimize their losses in the off-peak period by reducing the amount of energy sales.
Can you explain for me if and how Kelp would make adjustments of day-ahead nominations in real time?
Well, if they are operating at something below maximum output and Northwest asked them to increase operations, they would do so for the benefit of increasing the amount of capacity delivered during off-peak periods and increasing the amount of sales during the on-peak energy period.
Would it be possible then for Kelp to nominate, for example, 20 megawatts on a day-ahead basis and then rescind that nomination or take back that nomination in real time?
If they do, I think the Montana Consumer Council pointed out that there could be some ancillary charges that Kelp would be responsible for energy balances. So there would be ways of keeping the other customers whole if that were to occur.
All right. My last question for you concerns what you've described as the minimum operating threshold for Kelp that they would not fall below. If the economic conditions are not favorable for Kelp, is it possible that Kelp would nominate less than 20 megawatts of capacity in off-peak hours or even nominate zero capacity?
It's possible, but because they want to be available to operate during the on-peak hours, it would create some operational challenges for them to come down too low below 20 megawatts and then come back up so they can operate during the on-peak hours. So from an operational standpoint, there's a lot of disadvantages to Kelp to operate like that. But in terms of the contract, I think you could conceive some scenarios where they would be allowed to do that.
Okay. Lastly, could you refer to your exhibit MPG 7, which I believe was the redlined power purchase agreement? There. I think it was included with your rebuttal testimony. Is that correct?
It is, yes. Oh, it's six.
I think it's MPG 6. I think 7 is the RFP.
I believe that in the red line of Northwestern's PPA, you mentioned earlier, there was a provision in Northwestern's proposed contract that may be valuable if a separate interconnection agreement is used. Do you recall that testimony?
Yes.
For my understanding, would that clause be useful if the commission were to adopt either of KELP's proposals for handling interconnection terms in this docket? In other words, if the interconnection terms were included as part of the PPA itself, or if the commission ordered the use of a modified interconnection agreement for KELP.
Frankly, I need to stop. I may pass that question to my colleague, Mr. Collins, because I need some time to think about that.
Very well. That's just fine by me. Mr. Chairman, no further questions.
Thank you. Commissioner Fielder, do you have any questions for this witness?
Yeah, yes, I do. Thank you, Mr. Chairman. I just wanted to go back to Mr. Gorman's testimony. One of the elemental arguments made or presented in the very beginning didn't really have to do with the technical details, but just this the statement that Northwestern Energy has refused to negotiate with KELP. And I'm seeing this information that shows that there's been a lot of communications and back and forth between Northwestern Energy and KELP. So I'm wondering what you mean, Mr. Gorman, by your statement that Northwestern Energy has refused to negotiate.
Well, KELP informed Northwestern many times that it was interested in a contract extension. They responded to their RFP for additional capacity resources, and based on all those offers to Northwestern to start negotiating a contract extension, Northwestern would not engage KELP in a constructive negotiation of a contract extension. So it's that simple. Is KELP has been very motivated to get a contract extension in place. Northwestern deferred negotiation till 6 months before the end of the current contract. KELP found that proposal to be operationally and financially placing difficulty on this facility and wanted a constructive negotiation up front. And Northwestern did not engage KELP in that request.
Thank you. Follow up, Mr. Chairman.
Please.
So the discussions that have occurred between Northwestern and KELP, you wouldn't classify as negotiations, but they've been other required discussions outside of contract terms?
There have been communications, but nothing specific to pricing on a PPA. KELP has made some initial efforts to put pricing terms on the table. Northwestern did not respond to those.
Okay.
There have been other interactions between the parties, but not a formal process to put together a PPA extension.
Okay, thank you. And another follow-up, Mr. Chairman.
Yes.
In your testimony, Mr. Gorman, you stated that Northwestern had made this determination not to enter contract negotiations due to an unwritten policy, not to enter negotiations until 6 months before the expiration of the current contract due to an unwritten policy. Do you have any idea why Have they given any indication why they have this unwritten policy and why they aren't entering that negotiation with Kelp?
But I do not. I believe they have suggested that they want to treat all QFs in a fair manner. But refusing to negotiate a price extension for an existing QF, I think places significant financial burdens and uncertainty on that QF. So the rationale of being fair at all QFs, I think is being missed by that policy.
Okay, thank you. That's all the questions I have for now, Mr. Chairman. Thank you.
Thank you, Commissioner Pinochi.
Thank you, Mr. Chairman. I've got several questions and could change direction with the answer I get. Would you like me to say follow up each time, or can I bypass that? Thank you. So the ratepayer is wanting me to come up with some questions they may want to ask. So I think right off the bat, they'd say, you were questioned about contracts with other QFs. The price that you charge for your power compared to other QFs, do you think you're the lowest, in the middle, on the high side? What's your feeling there?
I don't have all the other QFs, but all of them are based on avoided capacity and energy pricing. And our proposed pricing is also based on avoided capacity and energy pricing. So it's the same methodology. You know, those avoided capacity and energy prices change over time.
Do you feel that you're pretty competitive and you got a great price as a QF
Well,
for the consumer?
we are relying on Northwestern's integrated resource plan. What they selected is the best and most economic resource place in service in calendar year 2024. For the capacity price and for the energy price, we are proposing an energy price on a day ahead basis, which reasonably aligns with reasonable dispatch cost and energy cost incurrence for Northwestern on an actual operating basis. So we think it is consistent with their avoided cost pricing or their avoided cost.
Rates are at an all-time high. Consumer is really concerned about that, and they've made that very clear to me. We go to the open market when we can't get enough energy, and we're paying up to $900 a megawatt. At that time, I'm hoping they call you and say, we want 42 megawatts. We want 100%. Do you feel they do that at that time, or they're not, and they go out and pay 900 out of state and ratepayer pays it? What are your thoughts there?
Well, it's kind of a long story around that, but there's different ways to structure a pricing for this contract. You know, both Northwestern and we have agreed to rely on LMP energy pricing. So the structure of this price will always be based on that energy price, the LMP. What it does do is lock in capacity, which Northwestern needs to reliably provide firm service to its customers. That part is fixed. So under the pricing structure that we're working with on Northwestern, it doesn't have the that energy component that you're describing in your testimony. That's not to say that a different pricing structure couldn't.
Do they ever call you and say we need 100%, all 42 megawatts when before they go out of state and pay $900 a megawatt? I'm just curious. You ever get that call?
Under the current contract, it was stated that 35 megawatts would be provided at 100% load factor. So the contract limited how much energy Kelp could sell to Northwest Energy. It wasn't a physical limitation. It was a contractual limitation. So we did not use those contractual limits in this contract. Instead, we're making the contract available to where Kelp can provide all the capacity and energy it can deliver to Northwestern, and receive avoided capacity and energy prices for all that capacity and energy it delivers, and not create the same contractual limitations in the contract extension that existed under the current contract.
Ratepayer is concerned when two parties come to a disagreement, you're here in a hearing, that the ratepayer has to pay for this. And I was surprised to hear that Northwestern refused to negotiate or come to any kind of meeting with you, which then puts us in this position. You feel that we could have saved the ratepayer monies if you and Northwestern could have worked this out before coming to have a hearing like what we're having today?
I can't speak for Kelp on that, but personally, I think a more constructive interaction between the company and Kelp probably could have resolved this issue.
The ratepayer wants me to make it clear that they're trying to get me to encourage that. So I want to,
I think Kelp was
Tell
very
everybody
interested
that.
in a constructive interaction with Northwestern on this as well.
let's talk about line loss a little bit. We've opened a docket here, encouraging energy efficiency. And what surprises me is that line loss came up today. And what I'm told is the ratepayer just pays it. How come that didn't come out? What's the big deal? Ratepayer has to cover line loss. I encourage high efficiency power lines from 3M or CTC Global to cut a third in line loss. We have high efficiency transformers that change the voltage to be able to get to a higher capacity to meet the needs to get on transmission, which cut losses tremendously. There's no incentive to do it because it seems like the ratepayer covers that. So why question you about it if the ratepayer is paying that anyway? What's your answer to that?
Well, losses in the generation and transmission of electricity are just part of the cost of service.
That's right.
Pardon me. I think that the dispute here is if Kelp is compensated for the line loss, then Northwestern won't be able to charge customers for the line loss. In which case, the losses will be recovered by the utility and that price will not be reflected of what the utility recovers and remits to Kelp. That's the bottom line. The practical implications are whether or not Northwestern's transmission line loss may need more granular assessments within the development of line loss factor. Many utilities will actually have a generation level step up loss factor and then a transmission delivery loss factor. The two of them combined may equal what Northwestern refers to as the transmission loss factor. Without that granular nature, you can't differentiate the cost of losses from generation to bulk transmission versus the losses within the bulk transmission system itself. So I think that's part of it is that there's just not enough separation in the line loss factor for Northwestern to be able to separate the portion that applies to the generation function versus the portion that applies to the transmission function.
I got to ask this question. If you were to put in the high efficiency power line to your portion and high efficiency transformer, could you then capitalize and say get more money and actually over time be more profitable? Has anyone brought that up?
Well, that's more of the delivery component, which Kelp doesn't do. Kelp is a generator. They take power, then they step it up to bulk transmission voltage, and then Northwestern takes it and delivers it to their customers. So to the extent there can be efficiency in the actual delivery of the power after it is taken, control of it is taken by Northwestern, then that would be part of their cost.
No more questions. Thank you, Mr. Chairman.
Commissioner Brown,
No questions, Mr. Chairman.
and I have no questions. Any recross?
I have a few questions on recross, Chairman O'Donnell. Mr. Gorman, I believe you just testified that Kelp's frustrated that Northwestern would not engage in negotiations with Kelp, but it engaged with other QFs. Is that right?
My understanding, yes.
Are you aware that the commission has a rule that requires Northwestern to provide an avoided cost calculation upon request?
I didn't verify that within the rule itself. I imagine that would have been something that would have been laid on the table at the time negotiations would have begun.
Chairman O'Donnell, I just request the commission to take administrative notice of 38.5.1910, which requires Northwestern to provide an avoided cost calculation upon request.
So noted. I think your question to the witness was he aware of that? Not that it exists, but we will take administrative notice of that.
Thank you. Did KELP ever request Northwestern to provide a calculation of its avoided costs under that rule?
They let you know they were interested in discussing a per PPA contract extension. I can't specifically say whether or not they read the commission's rules and asked for an avoided cost calculation.
Are you aware that all those other QS we talked about earlier, and I'm referring to Trident, Meadowview, Meadowlark, Broadview, and Upland Dillon Argenta, all made requests for Northwestern's avoided costs under that rule?
I'm not aware if they made a request to Northwestern for that.
Do you have any reason to dispute that?
Objection. There's no evidence in the record one way or the other about the other arrangements, and I think the question calls for unreasonable speculation.
Do you agree with me that Northwestern can't prevent QS from establishing an LEO?
I think that's a legal question. But my understanding of FERC's definition of a LEO is financial commitment and commercial viability. And to the extent a QF can establish that, as KELP, I think, did around 1990, then an LEO probably should have been set at the date of that determination.
So are you saying KELP had an LEO for this new contract extension in 1990?
You asked me a general question about LEOs. And I'm telling you that my understanding is there's a demonstration of financial commitment and commercial viability. KELP has operated for over 3 decades. They made a financial commitment and they demonstrated commercial viability. If that's the standard for an LEO, then I think they probably met that in 1990.
So would there be any point in the contract term they had in the original contract?
I have not recommended KELP make that argument, but I'm responding to your questions about the rules concerning an LEO.
Northwestern couldn't have prevented KELP from sending a unilaterally signed LEO or a unilaterally signed PPA to it, could it?
Again, that's a legal question. I don't know whether or not the pricing terms within a unilaterally signed PPA would have started meaningful negotiations with Northwest.
Do you agree that KELP could have sent a unilaterally signed PPA to Northwestern before April 29th, 2022?
I'm not aware of anything that prevented them from doing that other than their effort to have a constructive negotiation with Northwestern.
I have no further questions.
No questions. Thank you.
Sorry for assuming. Any redirect?
Yes, thank you. Okay, Mr. Gorman, I'd like to go back to we'll take this in the order that it came in. We'll go back to some of the questions at the beginning of your cross-examination from Mr. Hensley. First of all, do you recall a series of questions about the selection of the appropriate proxy resource and whether that ought to be Dave Gates or Yellowstone? Do you recall those questions generally?
I do, yes.
Do you recall Mr. Hensley asking you questions about whether or not your use of the Yellowstone plant as a proxy resource means that you think that the kelp contract should be executed instead of Yellowstone proceeding forward to construction? Do you recall those questions?
I do, yes.
Does your use of the Yellowstone County Generating Station as a proxy resource for purposes of avoided cost calculation have any impact on the actual moving forward of Yellowstone and the ongoing construction of that project?
It does not. The capacity out for the Yellowstone did not render Northwestern capacity in balance, or certainly not in surplus. But it does indicate what Northwestern believed to be the next and most attractive economic resource for capacity additions in calendar year 2024. So the extension of the kelp contract at the same cost, fixed cost as Yellowstone, would allow Northwestern to secure two new resources at what it represents to be the marginal cost of capacity for its system in 2024, but to get an additional of 40 to 42 megawatts of capacity that it needs in order to bring its resources in line with its capacity obligation to provide firm service to its customers. So it's not in lieu of Yellowstone, but it's in combination with it that the two capacity resources can be used by Northwestern to serve the demands of their retail customers.
So when the commission is considering the appropriate proxy resource, is it fair to say that what is being asked of them is to consider whether a new unit at or like something at Dave Gates or a new unit at or like something at Yellowstone is likely to be the next best resource available to serve customers in the same time frame of the contract that's at issue here?
Yeah, that's right. It represents what is referred to as the marginal cost of capacity, which is then used to derive the avoided cost capacity price.
And the last time that Northwestern had a capacity shortfall and decided what kind of technology to employ, an expansion of Dave Gates or to construct the new facility at Yellowstone, which option did Northwestern pick?
It picked Yellowstone.
Later in the cross-examination from Mr. Hensley, do you recall a series of questions about whether or not essentially Northwestern can rely on kelp to provide needed capacity when under your contract, the capacity could be anywhere from 42 megawatts in a given hour to 22 megawatts in a given hour. And there was a discussion of how that flowed through the averaging process in the proposed PPA. Do you recall that discussion, sir?
I do.
As we look at the current PPA, does the current PPA have any minimum requirements in terms of how much energy at a minimum kelp must provide to Northwestern?
It does not.
And despite there being no minimum in the current PPA, how would you describe the way kelp has operated over the last 32 years in terms of providing consistent and reliable capacity and energy to Northwestern?
Kelp has consistently made an effort to provide the maximum amount of capacity and energy.
Chairman O'Donnell, just may I have an opportunity to void hear the witness, please? Mr. Gorman,
Yes. My microphone was.
have you operated Kelp's facility for over the last 30 years?
No,
So do you have any personal knowledge of how it operated over the last 30 years?
yes, I reviewed the actual historical delivery of capacity and energy from Kelp to Northwestern.
And that, who, do you even know who put that together?
It was data that was delivered from Kelp to us, and it was in the form of invoices from Northwest Energy for transactions with Kelp. We created databases outlining that capacity and energy delivery.
I would just object to the extent that the witness is providing testimony outside his personal knowledge and he's relying solely on hearsay in order to do that.
Mr. Chair, if I may. Mr. Hensley, so are you objecting on the basis of hearsay as well as lack of personal knowledge?
To the extent he's saying his personal knowledge relies on these other documents and statements that are outside of the record, then yes.
Question for both counsel, I suppose. Are the invoices in the record here?
So, if I might, in Exhibit MPG3 to the direct testimony of Mr. Gorman, he presents a detailed analysis of the output from the Kelp facility. Now, in the effort to keep the number of pages to a limited, we have presented only 2007 through 2021. The source of that, as is indicated in the exhibit, which is in the record, are invoices from Northwestern. As I sit here, I can't actually remember if Northwestern asked for those invoices in discovery, but the information is in the record and it was documented. And so I think it is perfectly reasonable for this witness to testify based on the information that's presented to the commission.
Yeah, I guess I'd have to have you rephrase your question then, because I think you were asking for things outside of that.
Fair enough. Confining yourself to the experience for the last 15 years, how would you characterize the ability of Kelp to provide reliable and consistent energy and capacity to Northwestern, notwithstanding the fact that the current contract has no minimum requirements?
Based on my review of Northwest invoices with Kelp and a summary of that, it leads me to conclude that Kelp has delivered consistent with the capacity and energy sales opportunities made available under that contract. As shown on my exhibit MPG3, the average capacity factor for the energy delivered relative to the peak demands, the hourly peak demands for Kelp delivery to Northwestern has been very high, which indicates a clear economic incentive to deliver capacity and energy in line with the contractual PPA agreement between Kelp and Northwestern.
Again, comparing the current PPA, though, to the proposed PPA, under the current PPA, while there is no minimum, there is a maximum amount of energy that Kelp is permitted to sell to Northwestern during the course of the year, correct?
Yeah, that's stated about 100% load factor of 35 megawatts.
And how does your proposed PPA change that cap on how much energy can come from Kelp to Northwestern?
Kelp actually had to reduce the amount of energy delivery under the current contract as it approached the maximum energy permitted under the contract. So they don't want that restriction going forward. So it doesn't include a maximum energy delivery under the new PPA because they are still economically motivated to provide as much capacity and energy to Northwestern as possible.
Later in the cross-examination from Mr. Hensley, do you recall a series of questions that related to the calculation that you performed in your rebuttal testimony, revising the capacity cost of a new 50 megawatt aeroderivative unit like the ones at Dave Gates, and questions relating to the dual fuel capability of that proxy unit?
I do, yes.
Okay. As a threshold matter, can you first sort of explain to the commission why it is that you think that if the aeroderivative unit is utilized as a proxy resource, that it is important to incorporate the cost of that dual fuel capability, given the nature of the gas supply to Dave Gates?
Because if the avoided the resources that are being used as proxy for one another have to provide relatively the same service to Northwestern. Kelp has been a capacity resource without fuel constraints that has been able to deliver capacity and energy at a relatively high capacity factor, even during periods of high demand on the system. In comparison, the Dave Gates facility, based on Northwestern's response to data requests, does not have a firm delivery point from the interstate pipeline to the Dave Gates facility itself. Consequently, at Dave Gates, they have backup fuel supply. So installing a new 50 megawatt aeroderivative that can only burn natural gas and may not also be able to burn the backup fuel source would mean that it could be interrupted at times of interruption to natural gas supply. So to put the two facilities on more of an equal footing, I relied on the company's integrated resource plan and chose an aeroderivative units that did have backup fuel supply. They identified 3 in their resource plan, in addition to the aeroderivative without backup fuel. One included backup fuel with fuel oil, roughly diesel engine oil, diesel fuel. And the second one was a backup fuel source of liquid natural gas, which means you would have a gas storage facility on site to operate the natural gas unit in the event natural gas supply was interrupted. The capital costs and the operating costs for these different aeroderivative units were identified by Northwestern in their 2019 and 2020 integrated resource plans. The costs for both capital costs for the installation and operating costs are different across the 3 resources. The capacity resource chose by Northwestern without backup fuel had an installed cost in 2018 of $1,336 per kW, with a fixed O&M cost in that same year of $13.38. The alternative 50 megawatt aeroderivative with LNG backup had an estimated installed cost of $1,780 per kW, with higher operating costs of $13.88 per kW per year. The unit that was in between those 2 numbers was aligned with what the 50 megawatt units at Dave Gates currently are at, and that includes a fuel oil or a diesel fuel backup fuel supply. And the cost of that unit was roughly in the middle of what the utility used and what I used in the avoided cost analysis. The capital cost was around $1,491 a kW per installed capacity, and $13.81 for operating cost.
Could I ask you to refer to page 44 of your rebuttal testimony, please? And let me know when you're there. On page 44 at table 7, am I correct that that is where you, in sort of tabular form, describe your estimated costs of an aeroderivative avoided capacity cost, as it's described there, both with backup fuel and without backup fuel? Do I have that correct?
You do, yes.
Okay. So the with backup fuel, as I think you discussed with Mr. Hensley, is associated with your decision to use an LNG backup for the reasons you discussed with him. Is that correct?
It is.
Okay. If the commission were to determine that the fuel oil or the diesel option was the superior methodology and use the aeroderivative option instead of the Yellowstone, if all those came to pass, do you have an estimate based on the figures that you just gave of what the excuse me, what the impact of that would be to, on an approximate basis, knowing you haven't done the math, but approximately what would that do to the impact of how would that change, excuse me, the $24.91 figure do you expect on table 7?
It would probably end up somewhere in the middle of averaging 1932, which is based on the company's marginal unit, and the aero unit with backup fuel of 2491, which is based on the LNG backup fuel. The number would likely be somewhere in approximately the middle of that range.
Can I please ask you now to take a look at the KELP petition, which is exhibit KELP 1 in this proceeding? Do you have that in front of you, sir?
Yes.
All right. Do you recall a series of questions from both Commissioner Fielder and Commissioner Panucci about your testimony about the Northwestern's refusal to negotiate, as you described it, with KELP during the time frame of essentially 2021 and early 2022? Do you recall that discussion with the commissioners?
Yes.
So first of all, sort of maybe working forward, I call your attention to Exhibit B to that petition. You could let me know when you have that in front of you.
I have it.
Okay. And can you just tell the commission, what is Exhibit B?
Exhibit B is a letter from Northwestern to KELP responding to the request for a contract extension.
Right. Can you read to the commission the first paragraph of that, please?
Thank you for your January 27, 2021 letter requesting a 5-year extension of KELP's contract. We have reviewed your letter and benefits you articulated to support an extension. As we previously discussed, Northwestern is not in a position to extend KELP's contract until it gets closer to its expiration date. It is Northwestern's policy to negotiate new contracts or extension within approximately 6 months of expiration of existing agreements.
Okay. And then if you would, can you read the last paragraph of that letter for the commission?
Northwestern is short of reliable capacity, and we continue to value the contribution KELP makes to the overall portfolio. We expect KELP to fulfill its contractual obligation through the term of the contract. As the expiration of the current contract draws closer, KELP may request an updated avoided cost calculation and a draft PPA to review. We encourage KELP to participate in future RFPs to provide energy beyond its existing commitment.
So notwithstanding whatever the rule may be from the Montana Commission about providing avoided cost pricing, based on this letter, when did Northwestern tell KELP that they would be able to request an updated avoided cost calculation?
When the contract draws closer, around 6 months before the end of the contract.
Okay. And is it based on this letter at this time frame that you concluded that Northwestern was unwilling to negotiate with KELP?
Yes.
Can you please turn to Exhibit D of that petition?
I'm there.
Okay. And can you tell the commission what is Exhibit D?
It is another letter from Northwestern to Owen Orndorff,
And when is
KELP?
that? Oh, excuse, sorry.
October 15th, 2021.
All right. So several months later, another letter is sent, correct?
Yes.
All right. Can you please read the first paragraph of that letter?
Thank you for your September 29, 2020 letter to Mr. Rowe requesting a 20-year extension of KELP's contract. We have reviewed your letter and the benefits you articulated to support an extension. The substance of your letter largely replicated the substance of your January 27, 2021 letter. Northwestern's position has not changed from my last letter in February.
Can you read the second paragraph, please?
As we previously discussed, Northwestern is not in a position to extend KELP's contract until it gets closer to expiration date in 2024. It is Northwestern's policy to negotiate new contracts or extensions within approximately 6 months of expiration of the existing agreements, depending on the complexity of the matter. Renegotiating much earlier than that would not yield an avoided cost rate or capacity rate compliant with Montana law or PURPA.
And then just lastly, can you read the last paragraph for the commission?
Northwestern is short of reliable capacity. We continue to value the contribution KELP makes to the overall portfolio. We expect KELP to fulfill its contractual obligations through the term of the contract. As the expiration of the current contract draws closer, KELP may request an updated avoided cost calculation and a draft PPA to review. We are likely to engage in another RFP process before the expiration of the KELP contract and would welcome KELP's participation in that process.
So again, notwithstanding any Montana rule, based on the letter that Northwestern's, well, let me just ask this. Can you just say who signed that letter?
Shannon Helm, Director of Regulatory Corporate Counsel.
That it's Heim?
The time?
Heim.
Oh, I'm sorry. Time, thank you.
So notwithstanding, again, any commission rule, based on this letter, when did Northwestern tell KELP that they would be able to request an avoided cost calculation?
Approximately 6 months before the end of their current PPA,
And that would be when?
around the beginning of 2024.
All right, so flip over one exhibit, Exhibit E.
There,
And this is a topic you discussed a little bit with, also with Mr. Hensley, but you see on April 29th, 2022, KELP sent a proposed amended and restated power sales agreement to Northwestern. Do you see that, sir?
yes.
Okay. Now, notwithstanding the fact that KELP sent this, a proposed PPA to Northwestern in April 29th of 2022, when was the first time that KELP was provided by Northwestern a version of a PPA that Northwestern would accept?
I believe it was in their intervenor testimony in this case.
So it wasn't until after a petition was filed that Northwestern even offered to KELP a proposed alternative PPA with proposed alternative pricing, correct?
It's my understanding.
Now, since that time, and just to clear up a point of potential confusion that I got from Commissioner Fielder's questions, in the course of your testimony today, you discuss discussions or back and forth between Northwestern and KELP. But is it fair to say that all of that back and forth has occurred only in the context of this case, subsequent to the time when Northwestern filed its proposed PPA with its proposed rates, and that back and forth then occurred through discovery and the submission of the rebuttal testimony? Is that correct?
That's my understanding, is no constructive interaction occurred until we filed this case.
Thank you, Mr. Gorman. I have no further questions of this witness.
Thank you.
You are temporarily excused. We've been in session now for just under 2 hours, and let's call a 15-minute break. Thank you. We're off the record.